Hello, everyone, and thank you for joining us today for our talk on harassment investigations and how to conduct them during a global pandemic. As lawyers and investigators, we have been getting a lot of questions lately about how these are being conducted during this time where we can't meet together in person. One of the questions that we get a lot is, how has the pandemic changed how we're doing these investigations? And do you think that this is a trend that will continue? In my view, there's actually been a great benefit to changing the format in which we've conducted investigations, in the sense that we are much more accessible by video, and the need to travel potentially long distances to interview witnesses and respondents is no longer an issue. So for organizations who are international or national in scope, this means that their HR directors may not need to fly across the country to conduct an interview with a potential witness or respondent. It also means that as an employer, you have greater options available to you as to who your investigator will be, and cost, may really not be an issue anymore. As for whether or not this will continue in the future, I do foresee that it will, just because of that very reason, the cost and time efficiencies that are realized by being able to conduct investigations in a virtual format. What about you, Samia? What's been your experience? What kind of questions are employers asking you?
Sure. So our role as external counsel, we are often provided with an internal investigation that's been already completed and litigation has commenced. Some common mistakes that we've seen in investigation reports include not providing the respondent with sufficient information to allow them to meaningfully respond to allegations. A respondent that's in a workplace investigation will need to have a sufficient understanding of what the allegations that have been made against them are so that they can meaningfully respond. Another issue that also arises is that a party may not be followed up with, whether that's a witness or another individual who may have relevant information. You want to ensure that you plug any holes in the investigation prior to concluding the investigation and finalizing your report. Another common mistake is failing to make a determination in the investigation report and simply stating that there's insufficient evidence to make a finding of what happened. An investigator's job is to reach a conclusion, even if the only evidence is the verbal account provided by two individuals. In many circumstances, we provide a valuable service to our clients by being a second set of eyes on a draft investigation report before it's issued in final form. This provides for the opportunity to fill in any gaps, either in the report or in the investigation process. Turning it back to you, Priya, another common question we get regarding workplace investigations is, when should an employer consider using external counsel? What are your thoughts on that?
That's a great question. Thank you, Samia. I would say there are 4 circumstances where an employer would want to seriously consider retaining an external investigator. The first scenario is where the allegations that are made are against a senior level individual in your organization. Like if it's against anyone on your management team or executive level team, you may want to have an external investigator. And the reason for that is you may not be able to find someone within your organization who could be neutral and impartial in assessing the allegations against them. They may also be very uncomfortable making findings against the person that they report to or who is the ultimate leader of the organization. The second circumstance would be where there's no one in the organization who has the skills to conduct an investigation. What's important to note here is that under the Occupational Health and Safety Act, employers are required to have a duty to conduct an investigation if there's been a harassment complaint, for example. The Ministry of Labor requires that an investigation be conducted that is reasonable in the circumstances. And when they assess whether or not the investigation is reasonable, they look at whether or not you have selected, a competent, neutral, unbiased investigator to conduct that investigation. And you'll have better chance of meeting that standard if the individual is outside of your organization and they're well trained. The third circumstance where you may want an external investigator is if there's a potential risk of litigation. So if you know that the allegations are serious and the findings could result in serious discipline against the individual, and that would likely be litigated, you may want to have someone external to your organization writing the report, so that if they're called as a witness, your witness is impartial, for one, trained at dealing with the types of questions they might get during an examination. And that they're also able to, in the first place, draft the report in such a way that may protect you in the litigation process. The last circumstance would be where you think you might want to be able to assert privilege, like solicitor-client privilege over the report, and shield it from being produced in any subsequent litigation. So I think those would be the 4 circumstances where you would want to retain external counsel. And none of this is to suggest that employers aren't eminently capable of handling these things in-house. It's really just where the allegations are against very senior people, they're very senior, serious allegations, or there's risk of litigation that you would want to go down that path. I guess I'll turn that back to you now, Samia. There's one more question that I've seen being asked, and that's, what are your top recommendations for an organization who wants to strengthen their workplace harassment protocols?
Sure. So there are 3 recommendations that I would suggest for an organization that wants to look at strengthening its investigation protocol. So the first one is to make sure that any internal investigators are properly trained on how to conduct an effective workplace investigation. So our firm provides workplace investigation training, including conducting investigation interviews, how to analyze investigation findings, and how to prepare a workplace investigation report. And we also provide training to individual organizations that want training for their team. The second recommendation is to use external counsel as a resource to help review draft investigation reports before the investigation has concluded and the report is finalized. This ensures that any holes in your report can be caught, and a report that is eventually produced is defensible down the road if you are in the middle of litigation. Finally, in many cases, organizations already have an internal team that is properly trained in workplace investigations and that can handle many of the workplace investigation issues that arise. However, any workplace complaints that involve senior level executives or may involve numerous witnesses and involve a lengthy investigation, those are circumstances where you want to look to retaining an external investigator to ensure that impartiality is maintained and to make sure that investigation reports can be completed promptly. So thank you very much for joining us on this chat into the common questions that arise during workplace investigations.
Thank you.